Over the past day, several of my colleagues issued statements calling for Judge Kavanaugh's confirmation hearing to be delayed. A lot of these colleagues have written me personal letters to my calling for Judge Kavanaugh's confirmation hearing to be delayed. Some of them have written me very personal letters about cover-ups or hiding or handling documents in ways that they perceive to be different from what other committee chairmen have done. They claim it's because, well, in regard to the delay of the hearing, they claim that it's because President Trump's former lawyer recently pleaded guilty to criminal violations of campaign finance law, allegedly at President Trump's direction. I'm not going to delay Judge Kavanaugh's nomination hearing. There's no precedent for delaying a hearing in these circumstances. In fact, just the opposite. There's clear precedent pointing the other direction. And I'll give you at least one. In 1994, President Clinton nominated Justice Breyer to the Supreme Court. At that time, President Clinton was under investigation by independent counsel Robert Fisk in connection with the Whitewater land deal. Indeed, President Clinton's own records were under grand jury subpoena. Yet the Senate confirmed Justice Breyer by a vote of 87-9 during all that. In fact, President Clinton was under investigation for much of his presidency and was even impeached for committing perjury. Obviously, he wasn't convicted. But through all this, the Senate didn't stop confirming his lifetime appointments to the bench. President Trump is not even close to being in the same legal situation as President Clinton, but obviously some people around here think he is. So my colleagues' plea to delay the hearing rings very false, considering the precedent I just gave. And maybe historians can give you more precedent. So I want to tell you why. Liberal outside groups and Senate Democratic leaders decided to oppose the president's Supreme Court nominee by any means necessary. They even said so. Some even announced their opposition before Judge Kavanaugh was nominated. The minority leader said he'd fight Judge Kavanaugh with everything he's got. Members of the Judiciary Committee announced their opposition before giving Judge Kavanaugh any consideration whatsoever. One member said voting for Judge Kavanaugh is, quote unquote, complicit in evil. Another member said that Judge Kavanaugh threatens destruction of the Constitution of the United States. The goal has always been the same: delay the confirmation process as much as possible and hope that the Democrats take over the United States Senate in the midterm elections. The ranking member's hometown newspaper reported on this strategy recently, and the headline called it an attempt to stall. The tragedies might change, the strategies may change, but the goal to obstruct confirmation process remain unchanged. First, Democratic leaders tried to apply the Biden rule, which bars confirmations in presidential elections, and which many Democrats previously said doesn't even exist. They tried to apply it to even midterm elections. When they used it, it was applied to just presidential elections. Now, when this strategy failed, because it was completely and flatly false, they changed strategies. They tried pushing for an unprecedented disclosure of Judge Kavanaugh's executive branch documents, even though we've already received more pages of such documents than any previous Supreme Court nominee. And this is on top of Judge Kavanaugh's 12-year judicial track record and other more relevant publicly available materials. Now they're trying to latch on to the legal troubles of President Trump's former associates. But as I just explained, there's no precedent or logical reason for the Senate to decline to proceed on Judge Kavanaugh's nomination in these circumstances. It's just another attempt to block Judge Kavanaugh's confirmation by any means necessary. Now, on a related note, we're working to make as many of the documents relevant to Judge Kavanaugh's nomination to the Supreme Court when we receive them publicly, or when we receive them, to publicly make them available as soon as possible. It's common practice, I hope everyone knows, to receive documents with a restriction called committee confidential until we can assure ourselves that we won't disclose sensitive, confidential information to the public in violation of the Presidential Records Act. Chairman Leahy, who's here on the floor with me, did so during Justice Kagan's confirmation process, and I'm doing the same. This gives Judiciary Committee members a jump start on reviewing documents, because otherwise, if you had to wait till they're all cleared, you wouldn't even be reading them yet. The goal is to make as many publicly available as possible, as soon as possible. I have promised to work with President Bush and President Trump to waive committee confidentiality when the law requires it for specific documents that my colleagues would like to use at confirmation hearings. This is also consistent with how the Judiciary Committee has handled this issue in the past. And of course, all of my Senate colleagues are welcome to review committee confidential documents at their convenience. Simply get in touch with my staff. The staff there will make sure that you have full access to the range of committee confidential documents. One of my colleagues tweeted this, quote, Chairman Grassley, now I'm not going to name this colleague because there's no point in embarrassing anybody to make a very strong point here about how ridiculous some of this argument has come. Quote, the tweet, Chairman Grassley unilaterally deemed Kavanaugh's records committee confidential. Penalty for release could include expulsion from the Senate, which hasn't happened since the Civil War for disloyalty to the Union. GOP is going that far to keep these things secret, end of quote. I hope all my colleagues see the absurdity of that tweet. Now, that person's kind of acting like the Senate has never received committee confidential documents before. It's common practice. And it happened in previous Supreme Court nominees, even under Democratic chairmen. So, to sum up, it is so regretful that some of my colleagues on the other side of the aisle have politicized this process so much, but also at the same time have short memories. I yield the floor.